State PWD informed me that some amount had already been sanctioned, maybe
So what we
already
can-
sanctioned by the
So what we will
mortgage.
do is this.
Yes.
We will say that you have received some verbal instructions
Yeah.
which you would like to put up in an affidavit.
Mm.
The respondent number 2 who was named here has gone.
Yes.
Who was the respondent number 2?
Regional officer, Guwahati Circle, mortgage.
What page? The regional officer, Ministry of Roads and Transport, he has left.
Delbert.
Adelbert Susgi he's transferred out, and someone else is in his place.
Yes, my lord. It seems that.
When was he transferred out?
My lord, he was transferred at Aizawl under NHDCIL company.
About what time ago?
My lord, I was not informed. He just informed me that he was transferred out.
He is now in Aizawl.
Yes, my lord.
So what? Okay. If that person has gone, you have to give the notice to a new person and maybe implead him. In the meantime, whom did you receive the call from? The present incumbent?
The present incumbent.
The present incumbent. Okay. This is the last order. Ms. So-and-so, Leonard CGSC, has informed this court today that the respondent number 2 in the contempt petition has been transferred from his post as Regional Officer, Ministry of Roads, Transport and Highway, and is presently posted at
NHIDCL.
HIDCL, and therefore he is not in a position to inform the court regarding the present status of compliance of the orders of the court. Ms. So-and-so appearing for the Ms. So-and-so has informed. You are appearing as
For the DC scholarship as well as the respondents from PWD.
no, there are no responses from PWD.
Newly implemented.
Newly implemented, Your Worship. 14.
Okay. Ms. So-and-so
13
appearing.
to 17.
Ms. So-and-so appearing for the respondent numbers 14 to 17 has submitted that she has received some verbal, some telephonic instructions yesterday evening that the process of compliance is underway, and she seeks some time to bring on record the status by way of an affidavit. Full stop. Prayer is allowed. She is allowed. The respondent number 14 to 17 are allowed.
Your Worship, pardon me, Your Worship, it's 14 to 16.
16, huh? Respondent number 14 to 16. Where I had said 14 to 17 earlier, change it to 14 to 16. Earlier also I had said someone. So the respondent numbers 14 to 16 are allowed a period of 2 weeks from today to file their affidavit on the present status of compliance. Stop. The matter will be listed again on 14th of October
Your Lordship, on the last week of October, please, I have some commitment on that week.
Please. On 28th of October,
Be obliged.
28th of October, full stop, the respondent number 2 shall also endeavor to file an affidavit regarding the steps taken by him during the period where he held the post of the regional officer, Ministry of Roads and Roads, Transport and Highway. Full stop. You also try to endeavor to file, because contempt, to my understanding, is personal. What he did and what he did not. That is what we will look into. And if you want full compliance, you have to serve the new incumbent a copy of the order of the court. Wait for some time and then try any pleading if he does not comply. Yes.
Item 2.
Item 2.
It's regarding that
We were
airship
on some-
certificate. My learned friend wanted to submit some citations.
Yes, you wanted to
my
give us
lord.
some citation, yes.
My lord, I have compiled the orders passed by this honorable court in several cases.
What was that, how was it resolved? Just tell us that.
Yes, these orders are similar in nature, like the way it was disposed of, my lord.
Impugned order is set aside. Needless to say, the consequential receipt certificate stands interfered with. Now the matter. Civil judge for reconsidering the airship certificate by hearing all the interests. Have you gone through this order?
No, my
I just want to show them, my lord, these are...
Just give him a copy. Come to page 3 of the first order.
Just a check.
So there it has been remanded back. Here after hearing all the interested parties.
Right.
So that if we remand the matter back, his airship certificate, in this case that you have before you,
Yes,
the
Your
respondent was not present in court.
Correct.
So what we will do is we'll say both of you are present, matter is remanded back, you appear on a particular day, file your objections to whatever you have to.
Yes.
Bringing on record the agreement that the Lok Adalat, this thing, conciliation and your fresh airship certificate.
In
Then pass a new order.
in that respect, Your Lordship, may I make one small submission,
Yes, yes.
just to counter that? In my humble opinion, and as per my understanding, in order to apply the principles of binding precedent, the facts have to be similar and the same. Now we have a situation. What my learned friend has
No,
just
we are
placed-
not going on all of that.
No, we're not going on that. Just
We are
if-
setting aside
if-
the airship certificate.
Understood. Just on the remand issue, on the issue of remand, because in my humble opinion, one additional or different fact can make a world of difference between conclusion in two cases, even when the same principles are applied in each case to similar
All right,
facts.
then we do
So,
it this way.
out-
We'll do it this way. We'll keep you and we'll keep you. We'll try to do it this way. We set aside the legal airship certificate. We give you the liberty to apply afresh.
Yes.
Without, I will say that the limitation will not count.
No, limitation cannot count, Your Lordship.
Because you are in a forum.
The reason being is that, Your Lordship, her husband has passed away only in November of last year.
And then
So 3 years is there.
you have that time.
But your lordship, the problem will be, like, admittedly, yes, that Lok Adalat award had been there, and it is an admitted fact that no one has challenged that Lok Adalat award. But looking at the legal heirship, like 2014 Act itself, then I am the legal heir, being the son of the deceased K.T. Khuma, Mr. K.T. Khuma. And if there is any other properties being involved in the present matter, then my chance of getting of inheriting the other properties through my late husband, because my late husband is the direct legal heir. So if let it be remanded back so that the original applicant, the husband will be then through him, I can apply for inheriting the properties.
Now once you set it aside, the airship certificate which was obtained by your husband goes.
Fraud.
I understand, my lord.
That airship certificate has to go.
I understand.
There is no other option that you have.
Yes.
Your Lordship, may I make
When
one?
he already has a heirship certificate on a particular,
LSU.
on a particular this thing, over some of the properties, he has got his legal heirship certificate. Now, if we allow you to apply afresh for whatever, suppose your husband did not take up a legal heirship certificate,
Yes.
you would have to apply afresh through your husband. There is no other option. What I find from his pleadings is that they are not averse to letting you have what you have through your husband legally.
Yes.
So within the family there must be some trust. What he is suggesting is that remanding the matter back will take more time because there will be a contest. They'll have to show that this part is this and this part is not that and this is that and this is that, and you'll be suffering more.
May I make one small suggestion, Your Lordship? If it makes them more comfortable, let them file afresh. We will give them a no objection certificate on affidavit, provided their application is as per the Lok Adalat
He's
agreement.
making a
That's
statement
all.
at the bar. I don't need to record that. He's
Then-
making a
then-
statement at the bar. You
then-
know him better than I do.
Let it
We'll
be
give him
recorded, my
NOC, no
lord.
problem.
No. What I'm saying is that I'll say that he has suggested that his clients would not be averse to cooperating in your legal heirship certificate, your application for legal heirship certificate, if the same is in accordance with
Lok Adalat.
Lok Adalat award.
Lok Adalat thing.
We will give them no objection also.
Then let his submission be recorded.
I'll record his submission
No problem.
that his client is not averse to doing so. Once you file the certificate,
In fact,
somewhere we have to believe people.
And my lord, limitation issue may also be
Why?
kindly observation
No,
may be made by
we'll
this
just make
honorable court.
we'll make a passing observation that
Yes.
since you were already before a court and this litigation was pending, if any question of limitation arises,
There's a
it will be
question.
decided on its own merits.
Your Lordship, the present heirship certificate that is in impugn right now, that was applied in 2023.
Because yours,
Because our father passed away in 1998. Even then, he did not file any application for condonation of the
No, that can be challenged.
We
are not going to object.
Your heirship certificate, which now you will apply, will be by the wife of the son of the person who owned
Yes,
the
this
property.
is
So her limitation starts after her husband expires.
That is in
But
So that was in
2025.
November 2024.
Yes.
That point I understand, my lord. But the problem is that during the lifetime of my husband,
He did not do
he
it.
did
Not
not-
your fault.
he
Not
did
your
not-
fault.
he did not obtain
You
the
are not
heirship
paying for a heirship certificate to him. You are paying for an heirship certificate to you. Your cause of action arises only on the demise of the person you are
Yes.
claiming through, not prior to that.
to me, through my husband. That's my understanding.
That is what.
Yes.
You will only claim it when the husband is not there. You could not have claimed anything before that.
So the difference will be if it is remanded back, then I am claiming through my husband by substituting him.
Because the remand
There is
can-
the difference, my lord.
Could be.
Otherwise,
No,
yes.
could be because, see, there will be some hassle you have to face. The process followed was not very correct. So you cannot have a smooth Batari ride. A well-oiled ride is not what you can hope for. They'll be jittery. It will be jittery.
Still they can participate
in
if
fact-
it is remanded back. Still
No,
they
no,
can
no, no.
participate
We don't
in
need to
that.
participate because
Yes, take down.
Yes.
Let us do it because I have to dictate another 2 judgments and I have to, the staff has also to take some time off. Yes. Heard Mr. So-and-so appearing for the appellant and also heard Mr. So-and-so who appearing for the
Sole respondent.
sole respondent. Full stop. The challenge in this appeal is to the order dated
Sorry, my lord.
5/7/2023.
Sorry for interruption, Your Lordship. I'm
Yes.
for respondent number 1. 2 and 3 are the
Pro forma,
government.
sorry.
They
The
don't
government
need
is
to appear. Who is it? The government who?
No, they are pro forma respondents.
They have no.
Who appears for them?
Miss Nunui had appeared previously. She was there. during
Today
the day.
Mary is appearing. Mrs. Mary.
Okay. She'll appear for both 2 and 3.
Yes.
She can appear for both.
She can,
Inform
she
her
can.
then. Inform her.
Yes.
And Miss So-and-so appearing for the
all
performer respondent
briefly.
number 2 and 3. The challenge in this appeal is to the order dated 5/7/2023 passed by the Learned Senior Civil Judge 3 Aizawl Judicial District, Aizawl, whereby an heirship certificate was granted to Shri Zosanj Zuala, I can't, it's difficult for me. You take it from here, you'll find it at page 2 of the appeal. I'm marking it as, I'm just underlining that word, right? To so and so on his application, which was registered as heirship certificate application number 911 of 2023. Full stop. The appellant and the respondent in this appeal are the, both are the wives?
Yes.
Yes.
Are the wives of late R. Zomawiya and late Zozangzuala Rokhum, respectively. Full stop. The admitted case, the admitted facts are that the father of late R. Zomawiya and Zozangzuala Rokhum, I'm trying to repeat the names so that I can get familiarized with them.
Yes.
Had owned certain property within the district, within the district of Aizawl, full stop. He expired on, any date of expiry?
14/4/1998.
14/4/1998, and in an attempt to settle the property amongst the family, they had approached the Lok Adalat,
Page 20.
in the year 1999, and case number H/C-3/99, L-40/2000-PCC within bracket capital A was taken up. Pursuant to the Lok Adalat sitting held on 18/10/2000, the parties arrived at a settlement. Full stop. For a ready reference, the terms of settlement are quoted herein below. You take from page 20, annexure 3. I have marked it as A2. The next page, page 21, it ends, okay? Page A to A. It is stated at the bar that pursuant to the said settlement, the parties were enjoying their individual shares. Full stop. Let's see. Who expired first of the two persons?
The appellant, Your Lordship.
The appellant. Okay.
R. Zomawiya.
R. Zomawiya met his demise on what day?
30/12/2017.
2017. Full stop. Then you see Zozangzuala Rokhum thereafter had made an application Where is that order? Made an application on, when did you file that application?
Page 29, ma'am.
27th day of June 2023 in the court of the senior civil judge, Aizawl District, Mizoram, under the provisions of section 30 within bracket 3 of the Mizo Marriage, Divorce and Inheritance of Property Act 2014 for a grant of heirship certificate in respect of the land covered by LSC number capital A, capital Z, capital L dash 17 of 1969, which is located at Barabazar, Daurpui, Aizawl, and registered in the name of Khauting Khuma alias K.T. Khuma.
I apologize to interrupt you,
Yes,
Lordship.
yes,
The date of filing the heirship application is 5/7/2023.
Okay, make it 5/7/2023 instead of 27 June 2023, make it 5/7. Okay. The learned senior civil judge 3 took up the matter on 5/7/2023 itself and allowed the application, directing issuance of heirship certificate in respect of LSC number AZL-17 of 1969 to the petitioner therein. Full stop. The it is stated that Zozangzuala Rokhum also met his demise on
15/11/2024.
to 15/11/2024. Full stop. Next. Notices were issued in this appeal on, when did you issue notice? Five 8/2025, and on receipt of notice, Mr. So-and-so has entered appearance on behalf of the respondent number 1. Full stop. Next para. We have heard the learned counsel for both the parties. Full stop. It is submitted on behalf of the appellants that the petition that the appellant did not have any prior notice of the application, heirship certificate application number 911 of 2023 being filed by late Zozangzuala Rokhum, and that records would reveal that the heirship certificate was granted on the same day that the petition was filed. The learned counsel for the appellants have drawn our attention to the terms of the settlement arrived at the Lok Adalat sitting to submit that the heirship certificate in favor of Zozangzuala Rokhum could not have been awarded to cover the entire property covered by LSC 17 of 69, since the settlement arrived at on 18/10/2000 had demarcated certain portion to the family of to the late husband of the present appellant. full stop. He has therefore prayed that the heirship certificate granted by the order dated 5/7/2023 deserves interference of this court and is required to be set aside. Full stop. Mr. Swenso, appearing for the respondent number 1, in his fairness, has submitted that the legal heir certificate does not contain a reference to the terms of settlement before the Lok Adalat, and therefore a modification in the same would be lawful and fair. Full stop. He has prayed that the matter be remanded back to the Court of the Senior Civil Judge 3 for a fresh adjudication by allowing all interested parties to participate in the proceedings of heirship application for heirship certificate, being application number 911 of 2023. Full stop. We have considered the submissions made on behalf of both the parties. Stop. Upon going through the records and documents annexed to the writ petition, which are not controverted, we notice that the heirship certificate granted on 5/7/2023 indeed does not take note of the terms of settlement entered into by the predecessors of the present appellant and the respondent number 1. Full stop. Without further going into the merits of the case, since it is apparent that prior notice was not issued to the other heirs of late K.T. Kumar, and the heirship certificate was issued on the same day itself, we set aside the order dated 5/7/2023, which had granted the heirship certificate to the husband, to the late husband of the present respondent number 1. Full stop. We have been informed during the proceedings that the appellant had also applied on the death of her husband for an heirship certificate with regard to the share of the property had applied for the property heirship certificate in respect of the properties which fell in the share of her husband pursuant to the terms of settlement arrived at before the Lok Adalat on 18/11/2000, and accordingly she has been granted an heirship certificate by you have the order of that, date of that order?
5th of October to 2020.
20?
20.
No. 5th of October 2020, okay. Which was granted to her by the order dated 5th of October 2020, passed in heirship certificate application number 9/43 of 2020. Full stop. It has been submitted at the bar by the learned counsel appearing for the appellant that his clients are not averse to any proceedings initiated by the respondent number 1 to claim a legal heirship certificate over the properties which fell in the share of her husband as per the terms of agreement arrived at before the Lok Adalat. In such view of the matter, instead of remanding the matter back to the Senior Civil Judge Aizawl District, the respondent number 1 is hereby granted liberty to approach afresh the competent court of law for issuance of an heirship certificate in terms of the agreement arrived at in the Lok Adalat. Full stop. We have declined to remand the matter back, keeping in view the fact that the application filed earlier by the late husband of the respondent number 1 would require amendments which could be time consuming and delay the proceedings. Full stop. We make it clear that if any issue of limitation arises in the event that the respondent number 1 files an application for heirship certificate, the court deciding the application shall keep in mind the fact that the cause of action for the respondent number 1 has arisen only on the demise of her husband, and therefore the application can be considered to be filed within the time frame allowed by law.
Worship, there's one small issue.
Yes.
Presently, as on date, the LSC is in the name of the respondent, the deceased respondent. So if that can be reverted to our grandfather, our father, so that
The entire LSC will come to you. No, it will not.
no, because presently it's registered in their name. As a result of the heirship certificate, they had mutated the
Then we
LSC.
do one thing now. Where we said that we set aside the order, we set aside that 5/7/2023. We set it aside somewhere, na? Huh? We set aside the order dated 5/7/2023, and all consequential action taken for substitution of the name of the heirs in the LSC, full stop. We just set it aside. We set aside whatever consequential.
We'll take the necessary steps.
And
Check with the
once
government.
you also make an application, he'll make an application, all your names will come up.
Otherwise, mutation is not the issue here.
Haha.
Mutation is not within the purview of the case, the present case. So let them pursue.
No. Whatever consequential
Yes, I
action
understand.
has happened after 5/7/2023,
Yes.
everything goes.
I understand. So
We'll
I think
take
we
it up
That
with
is
the
what we
concerned
said,
authority.
whatever
will be able
consequential.
to make an arrangement, my lord, within the family.
Make a settlement within the family.
We'll definitely make an attempt, Your Lordship.
Huh?
We will definitely make an attempt. I'm deeply obliged.
Anyways, everybody is now saying mediation is the best
Really.
possible.
That is there, Your Lordship.
Much obliged.
Anything else? Please. Call it. Let us see.
Hearing list, item 10.
Your Lordships had deferred it on Monday.
Haha.
Your Lordships had deferred it on Monday.
Yes.
It's an RFA, my lords. The issue is very simple here, my lords. We are only saying that the plaintiff failed to adduce any evidence, and the findings of the trial court are perverse. The decree could not have been decreed in favor of the plaintiff.
Now, if I take it up for disposal today, there is a difficulty.
My lords.
It's 4:15. I'll have to hear you for around 10-15 minutes. Him 10-15 minutes. 4:45 tomorrow morning. I forget it. I've got a very bad memory, so therefore I try to dictate today itself. Tomorrow also not possible, and day after tomorrow.
My lords, the only difficulty is that, my lords, he's a grade A contractor, my lords, the defendant, appellant today.
Yes.
And he's facing some trouble in, my lords, securing some contracts.
Why is that?
Because, my lords,
What is the order of the court?
My lords, ultimately,
What is the degree?
the decree is that the appellant has to pay an amount of 54 lakhs odd to the plaintiff.
So,
And
are
that-
they in execution now?
Not yet, my lords.
Have you come up with the execution?
No.
No. So, looking at the time constraint of the court and everything else, we assume you will not do it for the next 2 weeks. Let this matter come up immediately after the vacations.
As your lordship says.
Otherwise, if you take it up today, it will only be time consuming. We'll take up the time now
yes,
and we'll try to do it tomorrow also.
Yes.
And then I'll have to go back and then write something there. In any case, it will be only after the vacations.
As your lordship.
Yes, last
So, what do we say at the request of the counsels for the parties? List this matter immediately after the ensuing vacations, since urgency has been pressed on behalf of the appellant. Will that do? Immediately after the vacations it will come up. You want a fixed date?
My lords, we were hoping we'd get a fixed date, my lords.
Okay.
After ensuing vacation, it will be okay, lordship.
If your lordships
Because
could
if
give,
we give-
my lords,
No, consent on a date.
my lords, 9th of
9th?
October, if it's possible.
Instead of being hit by surprise on the earlier evening, now you know it's 9th.
My lords, because we've been trying to coordinate.
That is what I'm saying to him. If I say immediately after the vacation, you will come to know in the evening, tomorrow the matter is listed. It's a shock.
Anyway,
If you have a fixed date, at least you are prepared for that date, not before that date.
yes, 9 will be fine, lordship.
9th October.
9th, instead of immediately after vacation, make it at the request of the counsel for the petition, counsel for the parties, list the matter again on 9th of October, as urgency has been placed by the learned counsel for the appellants. Thank you. Thank you.